the reason we have three branches is that the framers of the Constitution wanted it to be difficult for the government to act. And it wanted to force the government to be able to act together. And my concern is that in the past decade, this Supreme Court has been less faithful to those principles than we would like. And that's dangerous for a democracy.
Well, that's brilliant, because that leads into what we wanted to begin to talk to you about. Before I do that, some context for our listeners. The theory of checks and balances was implemented by Montesquieu and was then put into place in the American Constitution. And the idea was that the different parts of the governmental system would counterbalance each other, such that the judiciary, were a president to become despotic and so on, would be able to counterbalance that through their legal practice. And as we've seen, Trump has, let's say, some power or some favor in the Supreme Court. And you write about that in your book, that you think the way that these justices go about it is problematic. Could you tell us a little bit about why you think that?
Yes, but first I want to say I appreciate your taking credit for our system. You are, of course, historically correct. But also, yes, the various branches. The reason we have three branches is that the framers of the Constitution wanted it to be difficult for the government to act, and it wanted to force the government to be able to act together. And my favorite description of what they had in mind is from Justice Brandeis, who talked about the, quote, friction, close quote, between the branches of government. He referred to it as friction, which slows the process down and presumably forces serious talk and contemplation. So that's how that works. My worry about our current Supreme Court is that over the decades and even centuries, our Supreme Court has developed a series of principles of judicial restraint, which are designed to confine the courts to the judicial process and keep them from interfering or meddling in the policymaking, legislative functions of government. In other words, to protect the checks and balances. Things like faithfulness to the Constitution, faithfulness to statutory text, following precedent, respecting the narrow, limited jurisdiction of courts. All of these are designed to keep the courts focused on the judicial function and not interfere with the legislative or executive functions. And my concern is that in the past decade, this Supreme Court has been less faithful to those principles than we would like, and that it has slowly, over a period of time, sort of 5-4 decision by 5-4 decision, or maybe now 6-3 decision by 6-3 decision, steadily increased its own power at the expense of the two political branches of government. And that's dangerous for a democracy.
Thank you, Judge Tatel. I think this might link a little bit to what you talk about in your book Vision, and I'm just going to quote a little section of that book, and maybe you can elucidate that quote a little bit for our listeners, and off the back of that, we can maybe get into a little bit of a discussion about maybe your experience as well. So in the book you write, "It was one thing to follow rulings I believe were wrong when they resulted from a judicial process I respected. It was quite another to be bound by the decisions of an institution I barely recognized." Could you maybe expand on that a little bit, and off the back of that, tell us about the stare decisis principle?
Sure. Well, you've asked two different questions there. Let me answer your question about the quote from the book. That sentence is in a paragraph which explains why, after 30 years on the court, I decided to retire.
Sure.
And I made that decision for lots of reasons, and the sentence you quoted was just one of the reasons. And what I was getting at there was that, the court I served on is an appeals court And our decisions are reviewed by the Supreme Court. And so and the decisions we issue are sometimes reversed by the Supreme Court. And the point I was making there is that for maybe the first 2/3 of my career as a judge, if the Supreme Court disagreed with me in a case, that was okay. It's the higher court, that's its job. And as long as it's applying the same rules I am, following statutes and precedent, if it reads them differently than I do, that's fine with me. And as a lower federal court judge, I'm bound by those decisions. My concern in recent years is that by the Supreme Court abandoning principles of judicial restraint that I think are critical to judging, it has produced opinions that not only I don't agree with, but I think are flawed from the point of view of proper judging. And to make matters worse, many of these opinions in the area of the environment and voting are having potentially quite serious consequences on the government. So here I was, a lower federal court judge, obligated to follow these opinions. And as they became more and more unprincipled, I became more and more uncomfortable applying them. And since I was obligated to, I really had no choice but to resign. Now, you ask about stare decisis.
Sorry, I kind of butchered the pronunciation of that as well.
So stare decisis is Latin for the principle in the U.S. courts that courts are bound by prior case decisions, prior decisions. Obviously, they can be overturned under limited circumstances, but the stability of the law, the consistency requires that courts follow precedent. Each decision of a court is a statement of the law, and that law needs to be followed by future courts. So it's critical to the stability of the system. There's another reason why following precedent is important, is that when you have a Supreme Court or a lower federal court, say composed of judges who are, just take for an example, the majority is appointed by Democratic presidents, following a decision issued by judges who are, a majority of which are appointed by Republicans, it sends a powerful signal to the public that this isn't politics, that judging is something different from politics, and that the judges are applying objective law to facts before them. So following precedent is critical to the rule of law in our system. Now, that doesn't mean it can't be overruled, and it is from time to time overruled, but it can only be done when there are solid, principled reasons for doing it, and when those reasons are clearly articulated by the court.
For 54 years, they were trying to get Roe v. Wade terminated, and I did it, and I'm proud to have done it.
So the checks and balances, which have been so critical to preserving our constitutional system and individual liberties, largely don't exist now. My concern is that in the past decade, this Supreme Court has been less faithful to those principles than we would like. And that's dangerous for a democracy. This book tells the story of so many people, that people see their own lives in my book.